Good morning, everyone, and welcome to the DFAC Child Protection and PSEH webinar. My name is Vicky at AFID's Learning Team. If you can hear me, could you please use the raise hand button to confirm the sound is coming through? Oh, thank you. Thanks for the confirmation. Before I hand over to our speaker, I would like to let you know that this webinar is recorded and will be uploaded to AFID's YouTube channel. When the YouTube link is ready, I'll send everyone a follow-up email and include a copy of the presentation slides. During the webinar, feel free to type in your questions as you go using the Q&A panel. I repeat, using the Q&A panel for questions, please. This is also where you can see the questions submitted by other participants. At the end of the webinar, please stay and complete a quick survey. We'd like to hear your feedback and suggestions. Now, without further ado, I'll hand over to our speaker, Kathleen Bombell from DFAC. Welcome, Kathleen.
Thanks, Vicky. Hi, everybody, and good morning. I think I can see you. You can see me. Okay, fantastic. Okay, so let's get started. So I hope you've all grabbed yourself a cup of tea or a glass of water because we've got a bit of a slog ahead of us. Some other things that we've shared with you that might be useful to have on hand is a copy of the SIA policy and the guidance note, and also the child protection policy and related guidance note. As I mentioned, I'm Kath and I work in DFAT's Preventing Sexual Exploitation, Abuse and Harassment team. My colleague Tony Hunt, unfortunately from the child protection area, couldn't be here today due to some sick children. So I'm going to do my best to cover off on both sides of both policies today. If there's anything I can't answer on the child protection side, I'm really happy to take it on notice and get back to you. So I hope you'll bear with me in that regards. Just a little bit about me. So I'm a development specialist. I've worked in international development going on 17 years for both government and non-government organisations. And I joined the SIA team recently in December last year to get this policy up and happening. I also have a background in child protection, domestic violence, and working in refugee settlement here in Australia. So a little bit of practical application to some of the work that we're going to talk about today. So just to kick off, on a serious note, some of the things we're going to be talking about today are sensitive, and it is expected that some participants might find the topics uncomfortable or disturbing. So if any time you need to leave the discussion, please do so and just take some time and seek support. You can do this either by contacting any of the points on the screen, so Lifeline, 1-800-RESPECT or Beyond Blue, and Sane Australia are all fantastic resources if this should happen to you. So just to kick off. So today, this is what are we going to talk about? In essence, today's about having a conversation. We're going to talk about both the SIA policy and the child protection policy and really focus on what are your responsibilities under them. You'll have to forgive my casualness. I find the best way to get the most out of these things is by making them useful to the participants. So I've put aside quite a bit of time at the end for questions. If there's something burning that you want to ask as we go along, please feel free to use the question panel, question and answer panel to do so. And if there's something I can answer on the fly, I will, but if it's better to pack it, we'll just play it by ear. Okay, so let's start with a little bit of background on the SIA policy. So looking at why we have a SIA policy. As I'm sure most of you are aware, following there's been some major revelations in regards to SIA over the last few years for the development space. We've had Oxfam scandals, UN scandals, and a number of international commitments, including. Sorry? Oh, I've got a bit of feedback. 1 second. Is that better? Yeah, sorry about that. A number of international commitments. So we've had the Tidewater Joint Statement on combating exploitation, sexual exploitation, abuse in development and humanitarian sectors, and also the Whistler Declaration. So after, I guess in 2008, DFAT undertook an internal review looking at how we manage SEAA, and a number of recommendations came out of that, including the recommendation that we we develop a SEAA policy. The Secretary directed us that it must apply to all our partners, including our staff. And this is really an opportunity for us to have a public-facing commitment to how serious we take this matter. In addition to that, after the Oxfam scandal, we've been working closely with a number of like-minded donors in this space and formed a technical working group. And this group developed a set of 22 commitments about how we deal with SEAA in the aid and humanitarian sector, of which 22 countries, including Australia, endorse this. And Australia has chosen to implement these commitments via commitments via the SEAA policy. We're the first Foreign Affairs Department to have a SEAA policy in place. There are other development agencies around that have them, but we are the first Foreign Affairs Department to have one. And all this is, I'm sure you understand, very timely considering the Me Too movement and the focus on these issues in the corporate space, including banks in Australia, for example. So the policy was released in April this year and has a zero tolerance of inaction to SEAA. So moving on a little bit on the child protection side. So where has this come from? The catalyst for this was following a 2002 UNICEF Save the Children report, which identified widespread sexual abuse and exploitation of children and aid workers in West African refugee camps. A follow-up study in 2008 found that this remained largely unchanged. An inquiry, in addition to this, an inquiry was conducted in 1996 in DFAT to look into allegations of pedophile activity within the Foreign Affairs portfolio, DFAT and AusAid, which implicated some AusAid and DFAT staff. We know that pedophiles exploit weak systems, such as those that are present in the environments that we work in across the world. And we know that pedophiles travel. A recent presentation by the New Zealand Council for International Development on SEAA reported that after the 2004 Boxing Day tsunami, over 60 convicted child sex offenders left Queensland and over 50 left New Zealand to visit affected areas. So this is a very real area for us. In addition, Australia's had the Royal Commission into Institutional Child Sexual Abuse, which reinforced the need for strong systems and governance practices. All Commonwealth departments are required to implement the 10 National Child Safe Principles by next year, and DFAT's well placed to do that. So these are, I guess, just to give you a little bit of context. Moving on to who do the policies apply to? So both, I've tried to include SEAA and child protection where possible in the same conversation. There are some slight differences that I'll point out, but in regards to scope, we've got, so in essence, the policies apply to all DFAT partners, and this is aid and non-aid. And on the child protection side, one of the differences currently, it relates only to funded partners. On the SEAA side, that's funded and non-funded partners. So that's one of the small differences there. The policies apply in all locations, including Australia, not just our high-risk situations. And there are 5 main groups. So looking at the SEAA policy, the 5 groups in scope are DFAT staff, and that includes all our staff in Australia, overseas, independent contractor. In addition, we have other internal policies and practices and agreements that we need to adhere to in regards to things like our code of conduct and our ethics manual. In regards to child protection, staff are not in scope, but we do have other policies that that cover off on this. So I just had a question come in asking, is the intention for DFAT to move child policy to apply to all DFAT staff? So just on that, that is something that we're considering, but we're due for our next review of the child protection policy, which is kicking off in the next couple of months. So that is the question that the review will address. So I don't have an answer, yes or no, but we hope to be informed by the review on that. So yes, so DFAT staff, DFAT partners, and that's pretty much all our partners. Of course, I mentioned funded on CP and all funded and non-funded on SEAR. Our downstream partners, and then when engaged in the delivery of DFAT related business. So that's for both SEAR and child protection. The way I guess we apply the question when we're looking at downstream partners is, so for example, if you're in an office in Jakarta and you had a contractor coming in to fix your air conditioner, they would not be considered a downstream partner engaged in the delivery of DFAT business. So they would not be in scope of the policy. However, if you had a downstream partner that was engaged to deliver DFAT activities under the contract that you have with DFAT, then yes, they would be covered, and that applies to both. A good rule is follow the money, when you're talking about downstream partners. Multilateral organisations are covered by both child protection and the SEAR policy, and these groups are expected to act in accordance with the principles and reporting requirements outlined in the policy. In addition, they must abide by their own relevant policies and international declarations, conventions, agreements, and domestic legal frameworks that relate to child protection and SEAR. And just reading another question that's come in. So in regards, so the question is, noting that the SEAR policy applies to partner governments, many staff working in developing countries have issues working on SEAR with governments in country. What work will DFAT be doing with partner governments? So I guess that's a fantastic question, because this is one of the areas that we have to approach on a case-by-case opportunity, case-by-case basis, looking for all the opportunities we can take. So we take all opportunities for advocacy, of course, at those very senior levels, government to government levels. But in addition to that, it comes down to the implementation of this. So when we have a direct funding arrangement or contract or project that we are working with a partner government directly, we are taking our opportunities to negotiate contract clauses on a case-by-case basis. And I guess, you know, we have all respect that partner governments are sovereign governments, and we can't dictate to them that they have to adopt Australia's policies, but we can use our political currency to advocate and encourage agreement on these areas, and we're working through a couple of them at the moment. Thanks. So the last answer, the last group that's in scope is partner governments, which we just touched a little bit on. So, and that's only in relation to the SEAR policy. So Australian government and Australian state and territory agencies are also covered by this, funded or non-funded, and other partner governments. And so these groups are expected to act in accordance to the principles and reporting obligations, but they must, we respect that they must also abide by their own relevant policies, international declarations and conventions where they are obligated to do so. Okay, so I'm going to focus a little bit on the SEAR policy principles at a moment, and as you'll see, there's 6 of them. I'm going to skip through them pretty quickly, but there's a couple I'd like to pay a bit of extra attention to. So the first one that needs a little bit of, I guess, unpacking is zero tolerance of inaction. And sometimes this gets read as zero tolerance on its own, and that brings assumptions that somehow a policy will make the high risk work we do in the high risk areas magically no longer have any incidents of SIA. So this is a policy and it sets out our expectations. It will not stop incidents of SIA occurring, but what we won't tolerate is inaction in this. So what we don't want to see is people sweeping it under the rug, ignoring reports, or really just, you know, putting their heads in the sand. We want to see leadership on this. So it's not zero. It doesn't mean that if there's an incident, we're not going to fund people, we're not going to partner with them anymore. You know, some of our best partners will be our highest reporters. The second one is strong leadership, which accelerates cultural change. So really, in essence, we're talking about cultural change in regards to power imbalances and gender inequality, which we'll talk a little bit about later. So we can't do that without leadership, and we're really looking for our partners to take a strong stance within their organisations on this issue. The third is victim survivor needs are prioritised, and I do want to emphasise that this is really important, that this is kept in mind in all the work we do in this space. And, you know, this underpins, I guess, what we're trying to get out of this. So a couple of things that I would like to talk about in regards to a victim or survivor-centred approach is that this approach must treat the victim or survivor with dignity and respect, involves them in any decision-making, provides them with comprehensive information, protects their privacy and confidentiality, and does not discriminate based on gender, age, race, ethnicity, ability, sexual orientation, or other characteristics. And always considers the need for counselling and health services to assist the victim or survivor with their recovery. So the fourth one is gender inequality and other power imbalances need to be addressed, and that is really what is at the core of SIA. And stronger reporting that will enhance accountability and transparency. And DFAT has also made commitments to report on our incidents of SIA to really set some the leadership on this. Okay, so have I gone too far? Okay, so I just wanted to highlight how we're implementing the phasing of the policy. So as most of you already know, the policy was released in April and came into effect for all DFAT staff. For our aid and humanitarian partners on scholarship programs that came into effect on the 1st of July. And with that, they have a 12-month period to become fully compliant. So that's where, I guess, the process we're going through with our partners at the moment. And that was done in recognition that it's unrealistic to introduce a policy and expect that our partners, given the range and capability variances of the people that we work with, that they would be able to be fully compliant immediately. So then on the 1st of October, it came into effect for all other DFAT implementing partners, including contractors. And this is really emphasising our corporate partners that we have. And again, they have 12 months for full compliance. And coming up on the 10th of December this year, we'll have, it'll come into play for our downstream partners. And again, there'll be 12 months for full compliance. But what we'd really like to see in this period is, I guess, plans that give us working with our partners to make sure we're going to meet this deadline. We don't want people sitting around going, oh, it doesn't matter to us for another 12 months. This is a time where we give meaningful implementation a go and make sure that we're on track. So moving on to the child protection policy. The policy has 5 principles. Again, zero tolerance, assessing and managing child protection risks and impact. And on that, an acknowledgement that all risks can't be eliminated, but they can be reduced by careful management through the life of an activity. And I've just got a question come in, so I'm just going to duck back for a moment. The question is, what does date of effect actually mean? And what does fully compliant mean? So only plans are required now, and the policies need to be in place by date of effect. So the date of effect is, so from a contractual perspective, we will ask our partners from the date of effect that they are in compliance with the policy. And what that means is if you are looking at the policy, you are obligated to be compliant within a period of 12 months. So fully compliant is the compliance period. So what we do not expect at this stage that partners will be fully compliant. We expect them to agree from a contractual perspective that they will be within the period, and that's by the SEER clause that will be in all our contracts going forward. And really what we're looking for here is how we work with partners to ensure that they are. And just to follow up from that, and Australian NGO and downstream partners need a SEER policy by date of compliance, not date of effect. So we're going to talk about that a little bit more when I get to minimum standards, but in essence, they need to meet their minimum standards, whatever they are, when we go through the risk process. So if they are low risk, they will need to have a SEER policy or equivalent documentation in place by the date, by the end of the compliance period, not the date of effect. And one more question on this, just triple checking my understanding. DFAT downstream partners are the partners of the organisations that are funded by DFAT. So I just want to clarify, it's about engaged in the delivery of DFAT business is the criteria we put out around that. Can you explain? So again, downstream partners, just to clarify, subcontractors or individuals, subs of subs, they're engaged in the delivery of DFAT business. Okay, so I'm just going to go back to, we were talking on risk management for child protection. So recapping, all risks can't be eliminated, but they can be reduced through careful management through the life cycle of an activity. Number 3 is a shared responsibility for child protection. What we're talking about here is collaboration, commitment, cooperation for our partners, and this is key to effectively managing risk to children. Partners will be held accountable for child protection policy compliance through audits and spot checks. Number 4 is procedural fairness. DFAT uses fair and proper procedures when making decisions that affect a person's rights or interests and expect partners to do the same. And then number 5 is recognition of the best interests of the child. And this is in line with the UNCRC. And this is, I guess, a test that we apply in all the decisions we make around actions when we receive a report, is what is in the best interests of the child here. And this also recognises that some children are particularly vulnerable, including children with disability, children affected by natural disasters and conflict, orphans and street children. So moving on to responsibilities. I can see that there's some more questions in downstream partners, and we've got a section on downstream partners, so I'm going to park that for now, and if I don't answer it, we'll come back to it. So responsibilities under both policies are basically risk management, risk assessment and management, applying the DFAT appropriate minimum standards, reporting concerns, behaving appropriately and comply with professional behaviours, and also appropriate use of images, which is on the child protection side. So I'd like to start by going into and exploring a bit on risk management for both. So in regards to both, risk management on both policies, there's an element of upfront preparation, and this is seen in our contracts to ensure that child protection and SEER contract clauses are included in all contracts, including with our downstream partners. Risk assessments, both are risk-based policies, and they need to assess the level of risk and consider risks in their core business. And we really want to see this included on organisational risk registers or risk management processes for organisations as well. So what we're talking about there is we don't want these issues managed in terms of risk separately. They should be part of the core business of what we do to manage risk in the work that we do. The second part of this is ongoing risk management, which also, of course, includes regular review. It's important that our partners are able to ask the question, how are we managing these risks in our team in the work that we do? So going a bit more specific now, looking at SEER. I'd like to break this down a bit. So looking at the SEER risk management, there's really questions that we need to ask are, do SEER risks exist? And remember to put in place there in the delivery of DFAT business. Then it's about naming that risk, putting it into the risk matrix or risk management plan that you have in place, add it to the risk assessment tool and apply the appropriate minimum standards. So in this, what we're talking about here is every investment in contract really needs to ask the question, is there a risk of SEER occurring in the delivery of DFAT business? So what might help here is if I give you an example of where there is not one. So if I was to do a risk assessment on the provision of a mobile phone contract for a staff member working on a DFAT funded program in Indonesia, again, the risk of SEER occurring in the delivery of that mobile phone contract would be nil because they pay the bill remotely and the service is provided remotely. So that would be an easy no. There is no risk, SEER risk in the delivery of that DFAT business. Unfortunately, where there's people involved, there's usually some risk. So mostly we'll always get at least a low risk come up. If there is a risk, we need to name the risk, put it in your risk management processes. And there's a guidance note on our SEER risk guidance note, provides guidance on what factors you need to consider that can exacerbate SEER risk. And that's at table 6 at the last 2 pages of that document. Otherwise, SEER risk should be managed like any other risk by using your processes to determine the likelihood and consequence. So once you determine the level of risk, either low, medium, high, or very high, this determines what minimum standards need to be applied. So the minimum standards are in both the SEER policy and in the risk guidance note in more detail. So I'd like to talk a little bit more about risk factors. So when we're talking about risk factors for SEER, we're talking about things like when people are deployed away from their usual country of residence, if they're working remote or rural locations, to humanitarian or emergency settings, or who are unaccompanied. Where there's interaction with individuals, especially women who are or with people who are experiencing increased vulnerability. And that might include young adults, people with disability, people of minority groups, or including sexual minorities, people experiencing poverty, people who are sex workers, people who are part of families impacted by disasters, displaced people, refugees, migrants, or asylum seekers, people who are part of female-headed households, people who are survivors or victims of trafficking or other forms of gender-based violence, people who are in contact with the law, and people who are accessing residential or shelter services. So then we move on to other risks, circumstances, people who, where there are circumstances that staff have access to sensitive or confidential information So this creates a power imbalance in some circumstances. So that could include healthcare workers, counselling services, medical personnel, humanitarian or aid contractors. High-risk activities, for example, we consider high risk to be in our construction or infrastructure industries, considering these can have a higher risk of SEER given that construction industry is predominantly male-dominated, and we often see a lot of the other factors play out in these contracts, including the temporary movement of workers from one area to another, humanitarian areas, disaster response, and security and conflict work. And the last one is around provisions of goods and services that create power imbalances. So we've got women escaping trafficking or gender-based violence, food distribution, medical supplies, emergency supplies following a disaster again, residential shelter or shelter services, disability services, justice facilities, counselling and support services, community consultation, data collection, surveying and training, health sector programs, parenting and child protection programs. So I'm happy to, when we send out this, I'll share with you a couple of the risks, but all these risks are mentioned if you go to table 6 in the risk guidance note. The last 2 tables of that risk guidance note explores factors that exacerbate SEER risk. So the other risks that we consider there are organisational and reputational risks. So organisational risks, the red flags for us would be poor leadership on SEER, organisations with very hierarchical structures. Any organisation that has a historic lack of diversity in the workplace is also a very big red flag. Organisations that fail to consider SEER in their core organisational policies and procedures. Organisations with poor reporting mechanisms, organisations with geographically isolated workspaces or with very young workforces. Any workforces that normalise sexual banter or behaviour, and those that tolerate or encourage alcohol consumption. In addition to that, it's good for people to consider the reputational risks, and so this occurs to both reputational risks to DFAT and to your own organisations, and this looks at media engagement, branding, the profile of people involved, so if it's a high profile activity or there's political engagement, we would consider them to have risk, heightened reputational risk factors. And again, these factors are also mapped out in table 6 on the risk guidance note for SEER. So depending on the risk factors, you'd come up with a level of risk, and that would be either low, medium, high, or very high. And then you would apply the minimum standards, the SEER minimum standards accordingly. So 1 and 2 is for low cases, which, well, it's for all of them, but so let's say low or above 1 or 2, which is have a SEER policy in place, and 2, have a reporting investigation procedures in place. And so these, again, are mapped out in detail on your, in the SEER policy, and more guidance is provided with examples on how you would meet these in the risk guidance note. And I just want to go back to number 1 on this, to be specific, where we talk about a SEER policy or other documented policies and procedures in place that clearly communicate the expectations of the DFAT policy. So what we're talking about there, the child protection policy obligates partners to have a specific child protection policy. This is a little bit different. We don't need a specific one. We need to be assured that SEER is explicitly managed either directly through your core existing policies that exist, and that might be through your code of conduct, your human resources processes, your screening processes, and that if there's enough evidence there that you don't need a standalone policy and we're convinced of that, that's great. But you can also have a policy. So just making that distinction between the two. For medium risk, it is to have it's 1 and 2, plus have a risk management process in place that include explicitly managing risks of SIA. I've just got a question. The standards related to fraternisation appear to be aimed at sexual relationships. However, fraternisation is defined as associating brotherly or in a friendly way. I'll speak to that a little bit more when we go through a couple of slides on that down the track, but we have a specific definition that we use based on the AFP's definition of fraternisation, and we can explore that a bit further. Okay, so for high recruitment, so for anything that is considered high risk, what we are talking about there is applying standards 1 to 4 plus 4 and 5, sorry, which is effective SIA training in place for your staff and partners. And 5 is recruitment and screening processes and employment practice address and manage the risk of SIA. So that as I mentioned, they're exploring in the risk guidance note. There's some really good examples about what we mean by that. And then we get down to our very high. And so here we're talking about the prohibiting of transactional sex for all personnel while engaged in the direct delivery of DPAT business. And 7 is the prohibiting fraternisation for all non-national personnel while engaged in the direct delivery of DPAT business. So the key thing for there is our very high situations. We're talking about very high risk of SIA. So that takes us back to the risk guidance note and looking at where we consider that the risk is very great. And the reason for this is not that we think that for a moment that all transactional sex is exploitative, but in the very high risk situations, the risk of it being exploitative is too great. As I mentioned, we're going to talk a little bit more about fraternisation and transactional sex now. So it is one of the things that I guess has generated the most discussion throughout the development of this policy. So on, I guess the point I would like to highlight here is, again, this is only required for very high risk situations. So on transactional sex, men and women can be sexually exploited through transactional sex, which is exchange of money, employment, goods or services for sexual acts, even in places where sex work is legal. After a crisis, people may engage in transactional sex to generate income and meet basic survival needs. For a person purchasing sex in this setting, it is often impossible to distinguish between exploitative and non-exploitative transactional sex. So that is why we have decided to include it. In regards to fraternisation, being a SIA policy, we are more interested in the sexual side of things. However, fraternisation in this regard refers to any relationship occurring in the course of conducting business that involves or appears to involve partiality, preferential treatment, or improper use of rank or position, including but not limited to voluntary sexual behaviour. It includes sexual behaviour not amounting to intercourse, a close emotional relationship involving public displays of affection or private intimacy, and the public expression of intimate relationships. So if you look at in your copy of the SIA policy, there is a definition and for both of these terms in the glossary. And in addition, we've got a special information box in the policy that explores this. The reason that we've included this comes down to power imbalances. And when there is a significant power imbalance at play based on gender, age, ability, authority, social and economic inequality, and the potential for exploitative transactional sex and fraternisation is heightened. It is important to consider the context in which you are working and if they may give rise to exploitative sex and fraternisation. So any questions or concerns I'll address now, but anyone on this reporting? So we'll go into reporting down the track. Risk assessment that has not been answered yet. I'll go, so can I go back to Belinda's question? So if Australian NGOs and their downstream partner have taken a high risk approach to all activities identified in a risk matrix that is regularly reviewed, do we also need to document the actual risk assessment that identifies the level of risk? Because they are always taking the highest risk, therefore applying all 9 minimum standard policies and all SIA standards. Do we need a risk assessment tool if we're always applying? So yes, I get what you're asking there. Yes, you do. So these are not the only controls. These are what we mean by minimum standards. This is the basic, this is the absolute minimum that needs to be done. In addition to that, there will be management controls and your own risk management processes that address these risks in the work that you do. And that will be a matter, that will need to be fleshed out case by case, activity by activity, and organisation by organisation. These are the minimum standards, and they need to be contextualised and built on to make sure that they address the risks. So moving on, just I'd like to run through 3 quick scenarios because this isn't an interactive form place where I can put people in groups and walk you through. I just want to run through scenarios and ask you to think about the questions. So as I mentioned, if in scenario 1, you enter into a mobile contract for a new staff member with a telecommunications company. The staff member has been employed to manage a DFAT funded activity. The payments for this contract are funded by DFAT. Bills are electronically generated, paid online, and involve no direct contact with people. Is there a risk of SIA in the delivery of DFAT business here? So having a think about that, I already gave that example before, that would be a no. So to get the most out of these scenarios, I do recommend that these are the kind of things that you run through with your team and to generate discussion about how we manage risks in regards to SIA. So scenario 2, you have engaged a local catering company to provide and serve food at a Sydney-based public diplomacy event. This event will run for 2 hours, and your organisation will run for 2 hours, and your organisation staff and representatives from DFAT will be attending, along with media. Is there a risk of SIA in the delivery of this DFAT business, and why? So the questions, I guess, to generate discussions with your teams on that would be to look at that table 6 in your risk guidance note and suss out what factors are present that might exacerbate the risk of both the organisation that you're working with and the activity that they are undertaking. And then scenario 3, your organisation is entering into an agreement with DFAT to work in a humanitarian setting following a recent tsunami. Your organisation will be in charge of food distribution. Is there a risk of SIA? What is the level of risk? And then, I guess, knowing that, what minimum standards would you need to apply? So it's good to, if you have the chance, to go through scenarios like this with your teams, just to generate discussion and get people thinking about no risk, low and high risk situations and how the different minimum standards will apply. So I'm going to move So a question just came up before I move on. My national staff asked about rights for sex workers. So I guess I really want to be clear on this. We are not for a second saying that we are banning transactional sex for our partners. Sex work is a legitimate trade in Australia and they are protected by union rights. What we are banning is exploitative transactional sex, and I want to be really clear on that. Exploitative transactional sex is exploitation, and it is banned in all situations. And what we are saying that it's banned to exploit someone sexually is banned in low, medium, high, very high settings. In very high settings, we are banning all transactional sex because the power, we deem it too great a risk that there will be exploitation that takes place in that kind of a setting. So I hope that's answered that question. So moving on to risk management for child protection. You'll see with the child protection policies, it's a little bit more complex and a more of a mature approach to risk management. And the reason that we've done that is because we found ourselves in a bit of a conundrum where we were asking the question to partners, does this activity involve any contact with children? Will it be working with children? And it was very easy for people to say, oh, well, no, we're just building a hospital. Without looking at the factors. And what we found is that when people go through this process and ask the questions, their answers often get changed. So there's a lot of guidance in this space, so just bear with me. And as I mentioned, I'm not primarily across all the child protection stuff. So if anything comes up here that's a bit tricky, I will defer for a response from someone more across everything, but I will do my very best, I promise. So we have taken a lot of the guesswork out of the child protection risk management process through establishing the risk context guidance note in the policy related guidance material. The first question that we ask when assessing the risk is about establishing the risk context. And that is where we ask, what is the level of contact with children? So before we look at risk, we talk about contact. Step one, and this is covered in step 1, part A of the child protection establish the risk context guidance note. Step two, once we've done that, then we look at what is the organisational risk. Is the organisation a child-focused organisation? And what we mean like that is by child focus is do the activities and their work focus on supporting children? And what are their systems? Do they have strong systems in place? And these are covered under step 2, part A and B of the same guidance note. And the third is if you go through the guidance note, it will provide you with suggested overall risk context and what minimum standards need to be in place. So basically we're going through there, what is the contact, what is the risk, and then what do we need to put in place, what controls and minimum standards to address this. So if you come up with a high or very high risk, so this is for all activities working with children and for child-focused organisations. All 9 of the minimum standard, default minimum standards need to be addressed. If you come up with moderate risk, that includes contact with children, which is different to working with children. This must apply the appropriate minimum standards, which we're going to talk about, which come up here. So these are the ones that have the asterisks next to them, which are reporting procedures, child protection training, risk assessment, safe recruitment and screening practices. So, at a minimum, those that have contact with children or are at moderate risk should have a risk assessment in place, safe recruitment screening. This can be done through verbal checks, criminal records checks, reporting processes in place, some training in child protection, including reporting processes. They should have a child protection policy, and this can be a simple statement. It doesn't need to be a very complex document with information that clearly expectations, clearly sets out your expectations, and it can be present in the other existing documents. It does not necessarily need to be its own standalone thing. Child protection reporting processes are absolutely crucial, and risk management processes. We have recruitment and screening practices, as I mentioned, and employment. The last one is on employment contracts, which must contain provisions for suspension or transfer to any other duties for an employee who's under investigation, and provisions to dismiss any employee after an investigation if so warranted. I'll come back to that one later. So, sorry, moving on to high risk settings in a child protection, for child protection. So I just want to talk about high risk settings. So the high risk settings we're talking about here are things like emergency or humanitarian work. This might be related to natural disasters or conflict, work in isolated locations, work that involves direct physical contact with children, visiting a child's place of school or residence, activities that involve the educational sector and settings, and child health facilities. So, sorry, another question though. So I'm just keeping my eye on the question, the asterisks. Can I please explain the, going back just to go through this. So these are the 9 standards. The question is, can I please clarify the asterisks on this slide again? So these are the 9 minimum standards that are in place when you have a high risk or very high risk. They must all be followed. That it also includes if you have, if the activity is working with children. The asterisks relate to contact with children, which is the next level down of risk, which is moderate risk. And so for them, we have 1, 2, 3, 4 specific ones that need to be put in place. Okay, so moving back along. Sorry, I've just lost my place for 1 second. So in regards to the high risk settings, we also have increased risks. So within the high risk settings, we are also always on the lookout for things like abandoned and orphaned children, unaccompanied children, children living with disability, children who have been abused or exploited, and children who are the primary caregivers of other children or adults. So, child protection. So, sorry, I've just lost my. Please bear with me for 1 second. All this, so as I mentioned, we have a lot more maturity around the guidance that we have for child protection, and we have this slide here basically outlines all the guidance notes that we have in existence currently that you can access to give yourselves a little bit more information on the sector that you're working with. So this covers things like how to establish the child risk context, which is that first, the child protection risk context, which is that first questions about, are we working with, do we have contact with children? Reporting and notifications, recruitment and screening, all the way down to things like education programs, humanitarian programs. So all this information is available on the DFAT website, and the link for that is provided below. So I'm just going to quickly skim through this activity on the child protection risk management. And these are, again, just things to talk about with your teams at a later time to get the most out of this, because we don't have the opportunity to do it as a group. But if your organisation is managing a shelter for women and children escaping violence, the shelter provides accommodation and counselling for 5 families, including boys up to the age of 14. The things we want to think about there are what is the contact with children, What level would that be? Would that be working with, or would that be contact? In this case, we'll explore that in a second, but it will be working with. There are some, what are some of the child protection risks involved in this activity? And that's something to really be fleshed out using the guidance note, and how could they be managed? So just diving into 2 risks that we'll explore. The next one, there's a very real risk that children may be abused by staff or volunteers. And because this is a high risk situation and it involves working with, all 9 standards apply. So this is where we would follow the 9 standards that we've talked about. In addition to that, we'd be looking at training. As part of that, we'd be looking at training, organisational policies and procedures. So training should cover things like your organisation's policies and procedures, how to recognise signs of abuse, how to respond to abuse, and how to report suspicions. It should also cover supervision and families, making sure families are aware of rights and behaviour expectations, and child-friendly reporting mechanisms. So the second risk is that could be that could come about through an activity like this, is that if the service does not address the specific need of children or adolescents in the delivery of this activity, it could be really focused on the needs of the mothers and not necessarily addressing any of the risks. So some controls for this would be, also in building on those controls that we were talking about before, would be provide training for staff and volunteers, looking at the impacts of violence against women on children, training that include training on child rights, child development, child-friendly psychological support methods, and including children in decision makings that will affect them, and making sure that the program provides safe areas. So these are just examples of some of the things that might come up in your discussions, and it's not an extensive list, it's just things to, I guess, get the conversation going. So moving on, I'd like to talk about reporting. Just checking the questions, very good. So reporting, as you'll see from this slide, there's a similar approach for both child protection and SEAR, and I'd just like to point out where they differ. So again, highlighting for SEAR that reporting needs to be in line with the victim or survivor wishes and when safe to do so. So DFAT expects 2 kinds of reporting under the policy. The first is mandatory and immediate within 2 working days of becoming aware of an incident, reporting by staff and business partners of any incident of SEAR related to the delivery of DFAT business, or that poses a significant reputational risk to DFAT or our partner. For example, an allegation against a senior staff member or of a partner organisation. The second type is mandatory reporting within 5 working days by staff and business partners of any alleged policy non-compliance. For example, this might be failure to adhere to minimum standards or principles, or failure to report an incident to us. For the child protection, on the child protection side, the DFAT Child Protection Framework requires staff to report all allegations or suspicions of child abuse, exploitation or harm related to DFAT business. These include allegations of child sex offences committed by any Australian citizen or permanent resident. Allegations or suspicions must be reported to Conduct Ethics. That's for us internally, for instance, and that's how we manage our own internally. In regards to reporting allegations, we also apply the rule when safe to do so, and safety needs to be paramount with reporting. We don't want you to wait until an allegation is substantiated. The fact that an allegation or suspicion has been raised is sufficient to commence the reporting process. As an individual, your job is not to investigate, only to report the concern. Personnel should never investigate the matter themselves without adequate training, and this could really put the child or themselves in danger or risk a loss of evidence. So in regards to how to report, what we have here is that on the SEER side, we have a dedicated inbox which you can access. You can send the notification to directly. The notification form is available on our DFAT website and the address is in front of you. And all reports, all forms need to be emailed to the address that's provided there. Again, highlighting that notification should only be made in line with the wishes of the victim or survivors, and whistleblower protection should be thought about as well. On the child protection side, and we are working towards streamlining this process through the review process that's coming up. Notification forms are also available on our website, and the address for sending them to is provided on that screen below. I'm just going to the questions for one moment. I have a question here with regards to the SEER policy non-compliance reporting. Would DFAT expect all alleged cases of sexual harassment within our own implementing partners' organisations to be reported? What if the alleged case has been handled within that time frame? So there's two questions there. So again, bringing you back to focus on the question, has the SEER incident occurred within the delivery of DFAT business? So if it is involved within a DFAT activity, if it's happened in your mail room between two staff members that have nothing to do with the DFAT business, then that's not something we need to be informed about. We would hope that you would be reporting those internally through your own existing processes and procedures, but the rule we need to keep bringing it back to is within the delivery of DFAT business. The second part of that question is, what if the alleged case has been handled within that time frame? Absolutely, we still want to know about it. So that would just be a matter of reporting the incident. It will be an open and shut case for us. So it can be handled in one email. Following on from that, would an alleged case of harassment need to be immediately reported as this would be an alleged incident of SEER? Again, going back to the rule in the delivery, if it occurred within the delivery of DFAT business. Okay, so moving on to how to group mandatory reporting. So some of the things I'd like you guys to have a think about here within your own organisations, and use this for really thinking about how reporting works in the work that you do. What are some of the barriers to reporting? What might stop you or make you hesitant to report? How does your organisation apply the principles of natural justice and procedural fairness? How do you apply victim survivor-centric process and make sure that reporting is done within the best interest of the child? How do we protect whistleblowers in our reporting processes? Reports can mean that the system is working, and I must highlight, it's never a bad thing to report, and we see this as the fact that things are, people are doing their jobs, things are working, and this can be an indication that people are taking this very seriously, and that's what we want to see. So the other question to clarify here is reporting a choice? So the answer to that is, in essence, no. A person with the knowledge of misconduct by another staff member or other should always report it. The purpose is to stop harm being done to the victim as soon as possible. So what should we report? The obligation to report concerns or suspicions, including those of colleagues and staff working in other organisations. That's our obligation under the policy. It's not necessary to have proof before reporting concerns. Even rumours should be reported, as they may be a sign that there's a serious problem. However, all concerns or suspicions must be reported in good faith. Making bad faith allegations in itself is subject to disciplinary procedures, should be subject to disciplinary procedures. So some of the other things to explore with your staff and your teams is unpacking reservations and fears relating to sharing concerns about behaviour within the organisation. And what you might find is within that, the fear is often, what if I'm wrong? But the concern should actually be, what if I'm right? So again, bringing it back, particularly on the child protection side, if you are right, how are we ensuring the best interest of the child are being addressed? Reporting. So just going double. So Stephanie, okay, so double checking, if a child or adult victim does not with the case, I think that's want the case reported, are we going to report it at all? So there's different, there's a differentiation I'd like to make here. On the SEER side, the victims of the victim or survivor's wishes need to be paramount. And if they report it to you and they say, I don't want this to go any further because A, I feel unsafe, or B, it will cause me more distress, then their wishes need to be respected at all time. With children, it's different, okay? So with children, what the rule you need to apply is what is in the best interest of this child, okay? And that is to get them safe and stop the abuse reporting. And so unfortunately for the child's wishes, sometimes we can't always follow them because they are not, they do not have, I guess, the maturity to always know what's in their best interest. And it's up to us as adults to make sure that the best interests of the child are being followed. I hope that answers that question. Okay, so moving on to investigations. Investigations must be undertaken by experienced and qualified professionals, and it's important to, that victim and survivor-centred approaches are followed at all times. So what we mean here is there's a real risk that if investigations aren't handled properly, they can put the victim and survivor at further risk. They can re-traumatize the victim, and they can also just really be done in an inappropriate way. It's important that anyone working with children for investigations, that investigations are always child-centric and undertaken by people with experience talking with children about child abuse issues. We really don't want to put the children at risk of more trauma. Okay, so just really quickly, I'm going to skim through the next couple of sections because I want to go through downstream partners. I'm going to go quickly through use of images because I know we discussed this last year, but if there's any questions that come up for that, I'll answer them remotely. So in regards to downstream partners, this brought up some questions earlier on, highlighting that both policies apply. Managing contractor or a partner is responsible for compliance, and DFAT will require evidence of this compliance. So downstream partners, just bringing that right slide up. It's contractors, subcontractors, partners, and any other entity engaged by DFAT partners to perform any DFAT related work. We know that this is really where we get down to the crux of it. This is where the risk lies. So the closer we get to the coalface, the greater the risks are, particularly with local partners, where we see that these are the partners that tend not to have these policies or processes or frameworks in place. And this is where also pedophiles exploit weak systems. So application of policy to downstream partners is the responsibility of the partner of whom DFAT has the agreement with, and they must ensure that their downstream organisations or individual subcontractors are child safe, managing SEER risks, and comply with the relevant minimum standards. So always bringing it back to the relevant minimum standards. So it's DFAT's job to make sure that this is happening. DFAT might ask for information on downstream compliance when undertaking a spot check or audit. So moving on to use of images. So I just want to quickly run through this. In regards to use of images, informed consent must be obtained by the child, parent or guardian in all situations for photographing or filming children or using children's images. Images must show children in a dignified and respectful manner and should adequately be clothed. Consent, we require informed consent of the child and their parent guardian before photographing or filming a child. Consent can be verbal. We just suggest you put on file that this has happened, so you create an official record. So just a question on this is, looking at the picture that's in front of you, does this picture meet the requirements of the child protection policy? So the answer on this is no. And this photo has actually been used in a number of previous aid in, publications. The reasons for this, sorry, which elements of the use of children images work does this picture meet? The problem we would take with this image is really that the child is inappropriately clothed. We would consider this image to not really be dignified, and the photo really shouldn't be taken if the child is in a vulnerable or submissive manner, and it really doesn't provide the child with any agency or anything like that. So in regards to a DFAT funded activity, we would not accept this kind of use of this kind of image. This one's just to moving on, I just want to make a point on file labels. Remember that predators are very tech savvy, and when you name your files and images and use accompanying text, do not use locations or names. Take out GPS data, because that will provide pedophiles with or predators with the information that they might be looking for on how to access children. And on this photo, this man has been on the run for 15 years and was found after photos of his tattoos were uploaded on social media, and police were able to find out his location using that GPS data. So just this, the reason we show this photo is to point out that the same thing can happen to the photos of children. People can use, predators can use that kind of GPS data to locate children that might be escaping family violence, or something along those lines. So the next photo is a good example. I'd just like to share with you how we can convey a message using an image without needing to show the face or identifying features of a child. So that's child protection. Just on the SIA side, I'd like people to keep in mind that sexual harassment and that SIA can also include the use of images. So that might be the sending of pornography, or the use of nude photos, or blackmailing people in regards to, or harassing people with sexual photos of sexual nature. So just be mindful that we have a digital world and that these things don't always involve people to people. So that pretty much wraps it up in terms of my presentation. If you were to take home anything from today, I'd like you to remember that the messages are, you must assess and manage SIA and child protection risks in all your activities. You must report all your concerns to DFAT, and you must behave appropriately and comply with the behavioural expectations under the policy, and do not, so that's it in a nutshell. If you have any questions, there's 2 contact details there. First, the SIA, send us an email if you have any questions, or give us a call. And on the child protection, the same details are there. So just to finish off, do we have questions? We've got 15 minutes for questions and answers, and I'm happy to take any on notice if we can't get through them all today. So where are we up to? Okay, do the downstream partners need to make their own SIA policies, or can it be included in their human resource policies? So just to clarify there, so that the organisation that has the relationship with DFAT needs to show DFAT how, within their own policies and procedures, how they comply with our SIA policy. And then that must also include how they will ensure that their downstream partners will meet the needs of their own policy or procedures. So within that, the answer is they can have their own SIA policies. They don't have to have an explicit SIA policy. It could be enough that you request and are provided with evidence that the downstream partners will comply with your own policies and procedures in this space, but you can also request for them to do that. And that decision needs to be made on a case-by-case basis, given your business and how it works. The second one is in the child protection policy review that's been mentioned, is it likely that the policy will also move to a survivor focus in line with the SEAR policy? That again, I can't answer that, but it is something that is a question. We're looking as closely as possible, how do we make the policies complement and align as much as possible. Another question on downstream partners. We're curious about any approaches to socialising SEAR policies with downstream partners with a learning rather than only compliance focus. So it's a really good point, because what we're talking about here is in essence cultural change of organisations, and compliance is only one part of that. So the things that we have found most useful is engaging with the people that do the activities. Of course, high-level information sharing on obligations is required, but where we get the most traction is when we share information and work with the people that are doing the work. So we are actually putting together a group of resources that will be available on our website shortly, where we've got some useful SEAR websites, which will include training options and policy options. And so that will be, please keep your eye out, and we'll share that with APFRID when that's pulled together. So coming down, talking about fraternisation. So the standards related to fraternisation appear to be aimed at sexual relationship. However, the fraternisation is defined as associating in a brotherly or friendly way. Could I please speak to the intent of this section of the policy and how this could be implemented practically? So I think we covered that in the presentation, but just to highlight, what we're talking about there is the forming of inappropriate relationships. And in the regards to this policy, we are interested in the sexual nature of that fraternisation. So I hope we've covered it, but please reach out if you have a further question on that wasn't covered in the fraternisation section. Reporting procedures. Can child protection and SEAR reporting procedures be combined? Yes, they can. And they can also be combined with other mechanisms, but what we do ask is that however those processes work, that the people manning those processes are aware of their obligations to ensure that things are handled sensitively and appropriately. When you get the chance. The education about fraternisation in projects is not situation in disaster setting, is challenging, and the definition is perhaps not clear enough. Can you offer a scenario of the risk of fraternisation, please? Okay, so the risk of fraternisation, I guess, where I'd like to highlight, it would be if there was a relationship in a, we'll use an education setting again, between an Australian teacher teaching at a upper high school with children that were over the age of 18 or, college kind of age. So a forming of a relationship there. The sexual behaviour may not involve, the sexual relationship may not involve a transaction. So it's not classed as transactional sex or inappropriate exploitative transactional sex. So there might not be an exchange, but the power dynamics in place there, apart from, the obvious, there's a parent, a teacher and a student, apart from that, the power imbalance is so great that that relationship would be inappropriate and could not be considered a fair, equal, healthy relationship in those kind of settings. So I hope that helps. And so going back to a question here, I think my question was not well worded. What I meant was, if all 9 child protection standards and SEAR standards for those in very high risk are always applied to all organisational projects and level activities for all DFAT funded activity, contextual CP and SEER risks are identified, and those from a CP and SEER policy, but specific to the project activity. All level risks are identified and evidenced and managed well. Do we need to also show the risk assessment if we are also applying the minimum standards? Well, one of those minimum standards is to have risk management process in place, and that includes a risk assessment. So to have all of those in place, you would need to demonstrate that you have a risk assessment process in place. So otherwise you wouldn't be compliant with all. If that one's quite a long and complex question, so please feel free to reach out to me either through the phone or email, and we can maybe work that one through. In the case of child protection, we understand that staff must not be left alone with children. In SEER, must our staff try not to be alone with any adult? So I guess the thing there is to think about what is practically implementable. There is a greater risk when adults are left alone with other adults, and so there needs to be consideration within the way that you deliver activity that this is a risk and what controls can we put in place. So in essence, you offer greater protection to yourself to make sure that adults are not alone together, particularly where they're undertaking high risk activities such as food distribution and things like that. So wherever possible and practical, I would avoid it from an institutional, from an activity perspective, but really that's up to the organisation to think about how they will manage that risk. Adding to a question, could the example not be based on a sexual relationship of all? And I think that's in regards to the fraternisation question. So this is the fraternisation. Okay, so I'll just read out where we were, and maybe this might help. Please bear with me. That's it. So I'm not sure if you're asking me for another example of where it's a non-sexual example. So with fraternisation, apologies, I'm just pulling out my notes. Okay, fraternisation. I'll read this again. So the fraternisation refers to any relationship occurring in the course of conducting business that involves or appears to involve partiality, preferential treatment, or improper use of rank or position, including but not limited to voluntary sexual behaviour. It includes sexual behaviour, but not amounting to intercourse, a close emotional relationship involving public displays of affection or private intimacy, and the public expression of intimate relationships. So what we're saying there, it is not just the act of sexual intercourse, but other sexual behaviours are covered. If it was an inappropriate relation that had no sexual behaviours and no sexual context, it wouldn't be covered because it's a SEER policy and it's involved, and we are focused on the sexual nature of those activities. So in meeting the DFAT staff last week, it was said that the revised DFAT child protection policy will be released in early June 2020. Is that correct? If so, what time period will DFAT partners have to comply? So I guess I think so it will be a revised policy, not a new policy, and there will be some changes. We don't have a date for completion. We are working towards July, but once we get a time frame, we'll let our partners know. We're pretty sensible on this stuff. There will be a compliance period because we know these things take time, and we'll just work with our partners to make these changes as meaningful and practically implementable as possible. Okay, so next question. When we say personnel should never investigate without appropriate training, as that could increase risk. 1, do you count basic information gathering in order to understand and ascertain the context, details of an allegation in order to report and act effectively? And 2, are there standards materials to clarify what constitutes appropriate training for this? So So this question is covering both SEAR and child protection, so I need to answer it a little bit comprehensively. So in regards to basic information gathering, I think that the thing to take home on that is those things can be done so that you can report, but they should not stop you reporting, and they need to be done in a way that's safe and doesn't put the person at more risk. So they should not be a hindrance to you reporting, that you should report regardless, with or without them done. It shouldn't delay the report, but the information in what we don't want to see is people going off and try to substantiate things on their own before making a report and coming up with a proper investigation process. And that's what we're trying to avoid. And part 2 are the standards material to clarify what constitutes appropriate training. There are, but they are different for SEAR and they're different for child protection. So if you look at our website, we have some information on child protection and conducting child sensitive investigations, but there are, publicly available documents all over the internet for that kind of thing. In regards to training with SEAR, there's less information available on that because this is a newer space, but there are some resources that that are available online, and we'll share them through ACFID. For an organisation having an anniversary celebration where historic images meet all requirements except for having informed consent taken before standards in place, can those images be used for anniversary celebrations? That's a great question. I'm going to have to take that one on notice. Maybe, Bronwyn, you could send that to me in an email and I'll answer that one formally. There might be some other factors in play then in terms of timeframes and what processes that were taken. Okay, I completely agree that this image is not appropriate for use, and I assume we're talking about this use, this one, I hope. However, we are saying that all children must have T-shirts or other in all photos, e.g. at the beach and things like that. The policy does say that children must be adequately clothed, and the question about the beach and activity relevant clothing is a good one. I can't answer that off the top of my head, I do apologise, but I will circulate an answer through ACFID on that. What is the best way to document verbal consent? So verbal consent best way would be to create a formal file note explaining when, where, who, and that the consent was provided. Okay, yeah, thank you. When we said verbal consent, do we need to record it with a recorder, or just make note of? You don't need to record it with a verbal. Just document that a question has been asked and answered. In a meeting with no, we've answered that one. Just going to clarify. Okay, so just to clarify, going back to SEAR minimum standards, we are saying that unlike the child protection policy, where our implementing and downstream partners are required to have a child protection policy in place, with the SEAR policy, they don't have to have a policy in place. The key thing is that they can demonstrate that they are effectively managed SEAR risk through the code of conduct, for example, through their risk assessment. So on that, you're pretty close. So the bit I think that's missing from that statement is it is your organisation's responsibility to ensure that your downstream partners are managing those risks, and you need to be assured of that. So if you are assured by those things that is enough, given the risk and activity profile of the activity that this downstream partner is conducting, then that's great. Gather the evidence and record it, and that's what you need to do. But I would very strongly emphasize that what needs to be taken into account there is the risk profile of the activity And remember that this is where the risks are exacerbated. The further down the supply chain we go, the greater the risk. So keep that in mind as you make those assessments. We are now implementing partners visit schools where they are providing training for teachers and support improvements of physical infrastructure. We do visit schools where we obviously are in contact with a lot of children, but we do not work with children. Does this still make the child program a child focus and high risk? Yes, it does. We refer to screen specialists local. If we refer on to screen specialists local NGOs to support victims, as we are not a child protection NGO, will they be considered downstream partners? So in regards to the child protection policy, again, I must emphasize it's about downstream fund partners that receive funding from you to implement DFAT funded activities, so not referrals. But if you are funding them to undertake those referrals using DFAT money, then the answer would be yes. So it depends on the situation. A couple more questions. Will we provide an establishing the SEER risk assessment tool, similar to the child protection establishing the SEER risk assessment tool? No, and the reasons for that is that the child protection contexts are a little bit more complicated because it's about if there is contact with, working with, contact with, or nil contact with children. And so again, bringing it back to the principle that if there are people involved, there is a risk. So it's, you know, the answer is, in establishing the context, it's really asking the question, is there a risk of SEER occurring in the delivery of this business, this DFAT business? And if the answer is yes, then we negate the need for establishing the risk context. Then we go into a risk assessment instead. So slightly different process, and what we would jump to there is a full risk assessment. I'm a champ, thank you. If the inclusion of fraternisation is about the risk of sexual exploitation or potential, I am now clear. Oh, thank you. That was just thank you, not a question. Apologies about that. We are an Australian NGO with a branch operating overseas as the implementing partner of the same charity. What does the policy procedures need to look like for SEER and child protection as the implementing partner of one of those charities? An Australian NGO with a branch operating overseas. Okay, so I guess what we would expect you to do there is really go through the policy, and look at what the risk profile is of your NGO's activity, and how you need to apply the minimum standards for that. And I guess your policy would come out of that process. It's really not a question I can answer with the limited information, but I refer you to the documentation, work through that, and if you can't come to an answer, please do reach out. Just checking how we're going for time. If there is a time frame for completion of investigations, update to DFAT. So there's not a time frame for completion for investigations. Investigations, particularly those of a criminal nature, will be handed over to law enforcement, and they're out of the hands of everybody then. So there's no time frames, but we do, I guess the main thing to consider in that is that they are dealt with promptly and as quickly as possible, that things don't drag because of a lack of action on the part of our partners, and that they're dealt with as quickly as possible, really. So just going back to providing the contact details for the SEER and child protection team again. It's down the end. 1 second, guys. I apologise if I'm making you dizzy. So for, and these are in the child protection and SEER policies. So for SEER, these are the contacts here. So phone number, the address, and website for more information, and we can provide them, you know, please just look them up in the policies. And for child protection, the same phone number, child protection inbox, and an email, a DFAT address for more information. So we might wrap it up there. Just call out to everybody, if this presentation has raised questions for you or made you question how you're doing things, or you need more because I've made it more confusing, please do reach out. We are here to help. And I just want to commend everybody for the work that they are doing in this space. These are two really important areas that impact on across the work we do. And I can't, you know, being working in international development for many, many years, I can't understate the importance of this work. You know, it is crucial to our core business. So all respect to everybody and the work that we're doing in this really important space. Thank you very much.
Thanks, Kathleen. Thank you so much for answering so many questions. And thanks everyone for joining us. Now please stay and complete a quick survey.